The pre-deposition conference is a fancy term for any meetings or telephone conversations you have with your attorney at which or in which you discuss the upcoming deposition. Specifically, you should discuss with your retaining attorney the likely scope of questioning to help prepare you to answer more effectively. In general, the other attorney will ask you basic questions about your education, your background, and your experience in the industry. He will then question you about the specific sequence of steps you took during your research, investigation, or analyses to come to the conclusions you reached. He might take this chronological approach, but not necessarily. He may jump right in and ask you if you have opinions in the case and want to get right to it. So you should prepare yourself for any order of questioning. You and your attorney should always have such a preparatory conference. A conscientious pre-deposition conference with your attorney should be second nature to a well-prepared and well-organized team. It's also very much in your benefit to have this little preparedness be right before a deposition. Unfortunately, you will too often have to urge, cajole, and sometimes even force such a conference to occur. In a moment, I will give you specific strategies and purposes for such a meeting. If the week before the deposition arrives and you cannot easily answer all of the following questions, then you need that pre-deposition conference with your retaining attorney. You need to ask a series of questions of your attorney, such as, which documents does your retaining attorney believe are the most helpful and the most harmful to your side's overall presentation and position? You must understand the main points, then, that were made in those identified important documents. You should know whether they support or contradict the opinions expressed by you or the other expert. You should also know about the people who wrote, received, or distributed those documents, as well as their responsibilities in the organization. Another question you should be prepared for and prepared to answer is, what issues most interest the opposing attorney? This tells what your own attorney thinks is important. You should review this information and this line of possible questioning. Next, you should ask which of your opinions are the most important. Yes, you have already written your opinions. Now you can speak them. This guarantees that they get on the record. It also ensures that you have an opportunity to express why and how you came to those opinions and why you are so firmly convinced of their value to the case. You need to ask also what other information specific to the case and your expertise should you try to incorporate into your answers during deposition testimony. You should ask which of your opinions is most likely to draw the greatest fire from the opposing attorney. Where does your attorney think the strongest attacks on you and your opinions will come from? If you can anticipate potential weaknesses, you should be prepared to address them. If you expect potential attacks on the foundation for your opinions, you should be prepared to diffuse them. You should have clear and solid explanations of why those potential attacks or proposed alternatives should be discounted. Another question that's important to ask is what other facts or opinions in this case, such as opinions expressed by the other expert in their report, does your attorney want an additional opinion from you about? Not only should you be prepared to comment on anything the other expert has written, but you should discuss with your attorney the importance to his case strategy of such comments. At times, your testimony will negate or minimize the validity of the other expert's opinions. To whatever extent possible, you should prepare to do so at your deposition. Understanding your attorney's plans, tactics, and strategies, at least to the extent he will share them with you, will be invaluable to your preparation for your own deposition. At this point, if you've asked and gotten answers for all those questions, simply ask one final open-ended question of your own attorney. What else is important for me to know, prepare, or anticipate? You cannot answer all of these questions in a 5-minute walk to the deposition from your attorney's office. Yes, I've experienced that. Or in the half-hour coffee and cake before the deposition. Yes, I've experienced that too. My key tactic then is that if you have not gotten answers to all these questions in a pre-deposition conference, at least call your attorney on the phone and ask those questions. One interesting thing I discovered early on is that during these kinds of conversations that lead up to a deposition, your retaining attorney will ask you some questions. It may sound to you as if the attorney is trying to understand the technical facts of the case, that he maybe didn't understand them earlier. And you may answer as a teacher, trying to better explain things that you think the attorney still does not understand. You should know that attorneys will sometimes ask questions just before a deposition to gauge how your responses might sound during the deposition. It's a mini test rather than a mini coaching session. An attorney did this once for me, or to me in fact, but I didn't realize it until after the deposition was over, and he told me, "You know, you surprised me in there. You did a good job. I didn't expect that from your answers during our preliminary conference." If your attorney is asking you questions at this late stage in the case, just before the deposition, ask him whether he wants to know how you might answer such a question, or whether he needs the explanation. Now, sometimes you may be working on other cases. As you get a reputation, you may work on 2 or 3 or more cases at the same time with different attorneys. During depositions, the other side can ask you questions about other work that you are doing. You may have no protection regarding privileged conversations in the other case. The deposing attorney may simply want to determine whether your work in this case is consistent with your other work in current or previous cases. Occasionally, one of those other cases on which you are working will have required you to sign a confidentiality agreement regarding privileged information to which you may have access. The attorneys in that other case may expect you to maintain the confidentiality of the details of that case, or even the literal existence of the other case. If either of these applies to you and another case you may have, you should discuss the issue with your attorney prior to the deposition. To maintain confidentiality in these kinds of circumstances, your retaining attorney must seek a protective order for your testimony before the deposition. Put the burden on him to take care of that for you. Now, let's talk about settlement and possible settlements. Remember the earlier remarks I made about credibility with the jury? That credibility may affect a verdict if a trial occurs. Since most legal cases do settle, the opposing attorneys will note your credibility during this deposition. You will want the opposing side to know that you have performed a thorough analysis and that you have reached fair and objective opinions. If you convince them that you will probably present those opinions effectively at the trial, you will have increased the likelihood of a better and earlier settlement for your client as well. Credibility with the jury and credibility with opposing counsel and their clients is built not only on your fair and objective investigation, but on a fair and reasonable approach to the facts. This means that while you may hold strong to your own opinions, you need not fight against every opinion expressed by the other side. Accepting some opinions or facts that do not conflict directly with your own opinions will enhance your credibility because of your apparent reasonableness.